Welcome to today's webinar on implied covenants in the oil and gas lease. My name is Alice Hogue, and I'll be your instructor. Well, Boudreaux went into a bar, and the bartender asked him, he says, "What can I do for you today, Mr. Boudreaux?" And Boudreaux says, "I'll have 3 beers, please." So the bartender brought him 3 beers, and Boudreaux started to alternately, he sipped 1 beer, then he'd take a sip of the other beer, then he'd take a sip of the 3rd beer until they were gone. And then he ordered 3 more beers. And the bartender says, "Look, Boudreaux, I know you like them cold, but you don't have to order 3 at a time." He says, "I'll keep an eye out. And when you get low, I'll bring you a fresh cold one." But Boudreaux says, "Man, you don't understand." He says, "Man, I have 2 brothers. One is in New Orleans, and the other one is in North Louisiana in Shreveport. And we promised each other that we would, every Saturday night, we'd get together and we'd drink together. So right now, my brothers are having 2 beers too, and we're drinking together." Oh, man, the bartender thought that was a wonderful custom. And so every week, Boudreaux came in and he ordered his 3 beers. Then one week, Boudreaux comes in and he only orders 2 beers. And he drank those 2 beers, and then he ordered 2 more, and then he drank those 2 beers. And the bartender was feeling bad for him. He says, "Boudreaux," he says, "man, I know about what your custom is, and I just want to say, I'm sorry that one of your brothers died." And Boudreaux said, "Oh, no, my brothers are fine." He said, "Me, I gave up drinking for Lent." All right, so it was implied that they were drinking together when in fact they weren't drinking together. And what we're talking about today in the oil and gas lease is implied covenants in the oil and gas lease. What are implied covenants? Implied covenants are obligations that are imposed mainly on the lessee, even though they're not specifically stated in the lease itself. And these are called implied covenants, and they're there to promote the development of the natural resources. So let's look at what we'll cover today in today's presentation. Let's look at the agenda. So first, we're going to give you a basic introduction. I just want you to understand the terminology that we're using. We're talking about implied covenants. So I want you to be very familiar with those words. And really, the foundation for all of the covenants is this, what we call this reasonable, prudent operator standard. That is really the foundation that they all fall under. So these implied covenants are basically there to ensure that the lessee, the oil and gas company, or the operator, acts as a reasonable, prudent operator in light of all the circumstances. So those specific implied covenants are the implied covenant to protect from drainage, the implied covenant to market production, the implied covenant to reasonably develop the lease, and the implied covenant to further explore. So we're going to look at what each of these specific implied covenants are, but first we're going to look at just some basic definitions. As I said, the foundation for all of the implied obligations is this reasonable, prudent operator standard. And what it says is that there is a duty that's imposed in law that the operator has to act like in a manner appropriate to what a reasonable operator would do in the same circumstances. So now there is no duty to the operator if he's not able to recover oil and gas so that he can recoup his costs. So if he sees that there's no oil and gas under the ground, or there's oil and gas that can be recovered, but it won't equal the cost of his administrative expenses, his drilling, reworking equipment and protection well, then we would say that there's no reasonable operator standard. There's no requirement that they actually drill if it's not going to be profitable for them. Now, what is reasonable? We have to understand what is reasonable. Now, in the law, when we're talking about contract law or tort law or whatever it is, we use what's called a reasonable man standard. And what that says is that in light of the totality of the circumstances, what would a reasonable man do in a similar situation? That's the question we pose to a jury in a tort case. Under the totality of all the circumstances, what would someone that is reasonable do here? And that's how you determine whether or not there's liability. Well, the same thing applies in oil and gas law, but we call it the reasonable prudent operator. Because some of the things that lessors complain about is that the lessee damages the property, or the lessee prematurely abandons a well that's capable of producing profitably. The lessee has failed to use advanced production techniques, and he's failed to protect the lessor by seeking favorable administrative action. That's like pooling and unitization, those kinds of things. So those are the kind of things that a landowner will complain about. So then we have to look to the operator and see, did the operator act as someone who had the same facts, would typically act in the same manner? Now, note that it is reasonable prudent operator and not reasonably prudent operator. I was actually corrected in a class that I was giving one day because I was saying the reasonably prudent operator standard. It's not reasonably, reasonably prudent. No, it's a reasonable prudent operator. So I just want to give you a heads up. You won't make that mistake. So some of these duties that a reasonable prudent operator would have to do would be things like drilling replacement wells or reworking existing wells. Maybe they'd have to drill additional wells. That's what a reasonable prudent operator would do in light of all the circumstances. Maybe they would seek field-wide regulatory action like unitization at some point, where we can put more wells in shorter space. And, reclamation efforts to restore the property back to where it was before they were on it. So those are the things that we're looking at when we're talking about the reasonable prudent operator standard. Just cross through this so you don't get confused. And so that is really the foundation for all of these other duties. Is if you're acting as a reasonable prudent operator, you will naturally do the other requirements as an implied covenant. You will naturally protect from drainage. You will naturally market production. You will naturally reasonably develop the leases and further explore. But we have these implied obligations so we can sort of clarify what the responsibilities are that the lessee owns to the lessor. So let's look at what implied covenants are. When we're talking about implied covenants, there's a principle of contract law that's called the four corners of the document. And that means that we make an assumption that the contract embodies the complete agreement of the parties. So if there's something that happened outside of the agreement and there is some kind of a contract dispute, the courts are going to say, look, if it's not within the four corners of the document, we're going to presume it's not included in the agreement. Well, the implied covenant in an oil and gas lease is sort of an exception to that, because these covenants, these obligations of the lessee, are not written in the oil and gas lease itself. So they're implied. They're not written. And the covenant part of it is these are promises. These are obligations. Implied obligations, even though they're not specifically spelled out in the lease. And it's basically the promises and duties of the lessee included in the oil and gas lease, even though it's not in writing. And as we said, it's an exception to the four corners of the document. So where did we come up with this concept of implied covenants? Well, one is there is implied covenants at law, and there are implied covenants in fact. When we talk about implied covenants at law, what we're saying is that as a matter of public policy, certain things can't be waived. And what the law is trying to do here is level the playing field between the parties. The law favors upholding the contracts. So we're going to level the playing field and say, look, even if it's not within this agreement, you, oil and gas company, have superior bargaining power to this little old lady royalty owner or lessor. I read a statistic today that said the average royalty owner in Texas is a 65-year-old widow. So we are literally talking about a little old lady. So we're trying to balance that out. That's the public policy side of it. We want to ensure, even if she didn't have the knowledge to negotiate for herself, that there are certain things implied in oil and gas law, in the oil and gas lease, that are going to protect her. The other side of implied covenants is implied in fact. That is, to further the intent of the parties, because the lessee cannot seek to address every possible situation that arises. So we have what they call these implied covenants to kind of guide the operator along and to fill in the gaps to what is included or excluded in the oil and gas lease. So this principle of cooperation requires certain conduct by both parties, both as a matter of public policy when we're talking about at law, and is conducted intended by the parties when they entered into the contract, that is implied in fact. Now, you cannot have a clause, and someone tried this, you cannot have a clause in the oil and gas lease that say, we expressly negate the implied covenants of the oil and gas lease. That is, according to the Texas Supreme Court case, that is unconscionable. That is unconscionable. So you cannot negate these implied covenants. You cannot have any agreement where you waive these implied covenants. So that is what the implied covenants are and the sources of the implied covenants. Okay, so now let's look at the implied covenants themselves. And we're going to start with the duty to protect against drainage. This is a case, this was the duty to protect the leased property against drainage of the oil and gas pool. So it's kind of like an offset obligation in an oil and gas lease. Now, the case that established this was Texas Pacific Coal and Oil Company versus Baker, and the site for that is 6 Southwest 2nd, page 1031. And as you may have guessed, when we're talking about volume 6, we're talking pretty early on in the oil and gas legal history of Texas. And in fact, this case was a 1928 case. And it said basically that the operator has a duty to protect his leased premises, or the leased premises that the premises that he's leased from the landowner, against drainage. Now, this has mainly sort of been, and note this was in 1928, I believe Texas's pooling statutes were initiated in 1935. I believe that's correct. And so these laws were designed to protect the situation. They've really kind of been not as significant because now we have these pooling obligations and these state spacing obligations. And so usually that will take care of a situation where there's an offset well, that additional acreage or the acreage of the adjoining neighbor will be included in the pooled unit. Then you don't really have an obligation to drill an offset well to protect against drainage. Plus, it's also very difficult to prove drainage because the drainage has to be substantial before the lessee can maintain a cause of action. So the burden of proof is on the lessor, that is the person, that the mineral owner typically, to prove that there is substantial damage, that there's substantial drainage on the lessor's land, and that a reasonable, prudent operator would drill or would have acted to prevent the substantial drainage by drilling an offset well. But that is not the end of the burden for the lessor. The lessor then has to prove that the substantial damage had occurred and that an offset well would produce oil and gas in paying quantities. So you have to prove that there was damage to viable production. This is very difficult to prove, as you can imagine, because it's the same reason we implemented the rule of capture. How do you know where the oil comes from, whether it comes from the person's land that you're, the mineral owner whose land that you're on, or on the adjoining? So it's very difficult to prove. Now, the defenses that the lessee can use, they can prove that a protection well would be unprofitable. So they would basically prove that they would lose money if they had drilled a protection well. And the damages or the remedies would be lost income, the lost income that the lessor would have suffered. Courts are really reluctant to invalidate an oil and gas lease. So the damages for a breach of contract, whether it be a breach of the express language in the oil and gas lease or a breach of the implied covenant in the oil and gas lease, courts are usually going to say you have to notify the lessee, and the lessee is given a certain amount of time to fix the problem or to comply with the problem or comply with the request. And if they still do not comply, then you've got damages from lost income. Now, they can invalidate the lease. That's always the ultimate risk, that the lease is invalidated. But usually they're trying to maintain that lease, and so they'll usually have remedies that are monetary in nature. Okay, now the second duty that we're going to look at is the duty to market. This is a very broad implied covenant. And what it says is that, well, basically, what it's doing is it's saying that the oil and gas company has to market their production. And they have to market their production within a reasonable time and at a reasonable price. So in the case of Bristol v. Colorado, which I'm sorry, I don't have a site for you, these were the two elements that they were looking at, a reasonable time and a reasonable price. So in Bristol versus Colorado, the oil and gas company was unable to pipe the oil and gas it had drilled, and so they couldn't build, they didn't have a pipeline to connect to, and so the oil and gas company did not market that oil for 9 years. Is that a reasonable time? Under the totality of the circumstances, what would a reasonable, prudent operator have done? And the court held that due to the nature of gas and the lessee's diligence was a key factor in this case, building a pipeline, the delay was reasonable. So the court is going to take into consideration all the factors. There's no set time. And usually they're going to allow more time for gas because you have to build that pipeline than they are for oil. One of the key factors, as I said, was that they were diligent. They were continuously trying to build that pipeline, trying to market that gas. So that was a key factor. Now, there are some that say the whole purpose of this duty to market is to avoid the situation where a company engages in self-dealing. So what the company can do, and has done in the past, is that they can set up a shell company, and so they can have the gas that comes out of the pipeline, and they can have this shell company, not the oil and gas company Shell, but like an imaginary company, and they're going to sell it to this company for a very low price. Okay, let's say 10 cents an MCF. Okay, this company doesn't really care that it's a low price because it's the same company as this company, and then the company can then sell it at a profit. So what you've done is you sort of cheated the lessor. You've cheated the lessor because you've sold it to someone that is your own company, self-dealing, and you've sold it at the lowest possible price so that then you could turn around and sell it to somebody else at the best possible price. So the test that we're looking at is that it's got to be the best price possible for gas. And one way to determine whether or not it's a reasonable price is to look and see what other oil and gas companies are paying for the same gas from the same well. Remember, a lot of times these are under joint operating agreements, so you have several different working interest owners who are marketing their gas through the joint operating agreement. And so you look at what they're selling it for. So what are the other oil and gas companies in the same well? What is their annual price determination clause? That's going to be strong evidence of the market price and therefore strong evidence of the reasonable price in this case. Okay, but this goes further. This particular clause goes further because it includes the duty to produce and market, to operate with reasonable care, to use modern methods of production and development, and to seek favorable administrative action. And so the case we look at here is called Amico versus First Baptist. This is 529 Southwest 2nd. Let's see if I can do this here. Southwest 2nd, 563. And this is, again, another Texas case, a 1981 case. Now, what happened in this case, or the reason this case is relevant, is because it held that what happened was A sold oil from B's lease at below a market price to receive other benefits not related to B's lease. And so they held that the lessee is under an implied obligation to obtain the best possible price. So I'm not really sure what the facts are, but as an example, let's say you have company A here, and this is B's lease. And B says, hey, I'll market my gas to you, company D, at a lower rate than usual if you farm out your land in this section range. Okay, basically B is being deprived of his getting the best, most reasonable market price because you've cut a deal with D that has no benefit for B. And that's what the Amico First versus First Baptist said, is that the lessee is under an implied obligation to provide the best price possible. And you cannot, market it at less than the marketable price to receive benefits that aren't related to your lessor's lease. So basically, you cannot negotiate a lower rate for your lessor as a bargaining chip with other companies to obtain some benefit. All right, and we're going to still be on the market, the implied obligation to market production. So the implied covenant to market also obligates the lessee to incur post-production costs. All right, these are the costs required to transform raw gas into a marketable product. This is the hottest litigation going right now in the oil and gas industry. And the question is, does the lessor, okay, so you know how it works. Let's say it's a 1/8 lease. Let's see if I can do this here. All right, it's a 1/8 lease here. And that means that the oil and gas company owns these remaining 7/8. 7/8 for the oil and gas company. Now, there are costs that are associated with transforming raw gas into a marketable product. Who bears the cost for these post-production costs? Some states say, well, the lessor has to pay it out of his 1/8 royalty. That is the minority view. I'm going to give you a little bit more detail, but in Texas, it depends on the lease language. So in Texas, if the lease language says we're going to pay you the gross proceeds, that means the oil and gas company has to pay the post-production costs out of their 7/8, out of their share of it. But in Texas, if the lease says that we are going to pay you on gas for the net proceeds, that means we're going to pay you your 1/8 after we pay our costs. So basically, the lessor is then paying these post-production costs. That's the law in Texas. Louisiana is similar. Louisiana says the royalty owner or the lessor has to pay for the post-production costs. All other states say that the oil and gas company has to pay because of the implied covenant to market production. In other words, the oil and gas company, are the ones that have to make it marketable, and that is under the implied covenant to market production. So that's another very important part of the implied covenant to market. Now let's look at the duty to further explore. Now, the duty to further explore is defined by the AAPL. It says a producing field cannot hold non-producing lands or horizons of the lease indefinitely. All right, so it imposes obligations on the lessee once that initial development, once that initial well is drilled, to either keep drilling or drop the acreage. Now, what we're trying to do is the reasonable prudent operator has to maximize the profits. And so if they are on a formation, the way I think of this is the duty to further explore is basically a duty to prove up the formation. So it's breached when the lessee fails to explore the undeveloped parts of the property or formation on the property for more oil and gas. So if you have an oil and gas lease on the property and that is a productive lease, it would be reasonable. It would be what a reasonable, prudent operator would do is to say, hey, I wonder if there's other wells that would be equally productive on this lease. And then they would continue to drill wells to further prove up the prospect. So you can't be satisfied with just one well under the duty to further explore. And the whole concept is that further exploration could result in new oil and gas wells, and that the oil and gas company is not being prudent by failing or refusing to further explore. Again, our goal is to maximize the natural resources. And so that's why we have a duty to further explore. It's not enough that you drill one successful well. We want as many people as possible to be independent, not be wards of the state. And so we're going to impose a duty on you, an implied covenant, oil and gas company, that you have to prove up that prospect. You have to continue to drill until you understand or until we know exactly what is the maximum use of that formation. Sometimes this is referred to a drill or drop implied covenant because we're telling you, look, you got to keep drilling. You got to prove up that formation. Now, if it's not profitable to do so, a reasonable, prudent operator would not further explore. But the burden is on the lessee to prove that there was no further development that would have maximized the profits. Okay, the remedies for breach of the duty to further explore, and this is just like a breach of contract, a breach of an implied covenant is basically a term of the lease that's not written into the lease. So if you breach any of these implied covenants, you've got a lawsuit for breach of contract. The remedies are lease cancellation. This is a very severe, as many of you can understand, remedy. And it's, in fact, very rarely used. Usually, there is some kind of conditional lease cancellation where the lessor notifies the lessee, and the lessee has to comply with the standards, or if they don't take advantage, if they don't listen or pay attention, then we're going to cancel the lease. But first, we're going to give them, the oil and gas company, the opportunity to correct their mistakes. And in that case, if they comply, all is well, no harm, no foul. What we prefer to do is we prefer to maintain that lease. So a court may order damages, monetary damage, for the breach of the contract to further explore. But again, if it's really a profitable venture, there's really no reason why a reasonable, prudent operator wouldn't want to continue to develop it. So it benefits both parties, both the lessor and the lessee, if they continue to further develop the lands. Okay, so, or further explore the lands. I don't want to confuse you because the next implied covenant is the implied covenant to reasonably development. What think about when we're talking about further explore is we're just saying you got to prove up that formation. All right, that is different from the next implied covenant that we will look at, and that is the implied covenant to reasonably develop the land. Reasonably develop the land. And what it's saying basically is that essentially an economically motivated, prudent operator will fully develop the resources under his or her control within a reasonable time period. Now, this is distinguished from the implied covenant to further explore because we've basically already proved up the formation. Now we need to develop it to fully maximize the recovery. So once the lease is HBP, the lessee has to reasonably develop that lease. That means they might have replacement wells, they might have additional wells, they might unitize it, they might have increased density wells. And the lessor, in order to be successful in a breach of implied covenant to reasonable develop, has to prove that there are additional wells could have been drilled profitably and that the lessee has acted imprudently in failing to drill. So once the oil is discovered, the lessee has an obligation to continue to develop reasonably. And so as long as there may be production in paying quantities, then that lease is going to be maintained. Again, the public policy here is that we want to ensure that the natural resources are fully developed. So you can't just have a well on the property with a drip, drip, drip coming out of the well. It's got to be production in paying quantities. That is implied in the oil and gas lease. That is a clause in the oil and gas lease that says that the well will continue in force as long thereafter as oil or gas is produced. So there is a legal background to the term produced. It's not just, as I said, a drip, drip, drip. Courts have interpreted produced as implied that there is going to be production in paying quantities. This means that there is only a return, even if it's extremely tiny, of enough money to pay the current operating costs. That's what production in paying quantities is. It's the cost of getting the oil and gas to the wellhead and to the sales point. Now, a well can produce in paying quantities even if it will never pay out the costs of the drilling and equipping the well. It doesn't have to pay out, but so long as it pays the current operating costs, and a reasonable, prudent operator will continue to operate the well in hopes of eventually making a profit and not merely for speculation. So that is how you satisfy this implied duty to produce in paying quantities. And so those are the implied covenants that we're talking about. And just in summary, I just want to remind you that, these are obligations that are in addition to those that are already included in the lease language. And usually these implied obligations, or implied covenants as we sometimes call them, generally they are benefits that accrue to the landowner to ensure that the oil and gas company is acting as a reasonable, prudent operator. Now, there are some obligations that are on the part of the landowner. One is that they have to allow the lessee to enter across the property adjacent to the lease. So they have to provide a way for them to get to the property even beyond where their property boundaries are. And the lessee will drill what the lessor is expecting is that the oil and gas company will drill an initial exploratory well, that he will reasonably develop the property if the first well produces, that he's going to protect the property from drainage, that he's going to explore further, and that he will conduct with care and diligence all operations that affect the lessor's royalty interest, and that he will do his best to market the oil and gas produced, that he will not engage in self-dealing. And any breaches of the implied covenant are just like breaches in the oil and gas lease. They're going to bring court-awarded damages or cancellation of all or a portion of the lease. Very dire consequence that we want to avoid if at all possible. So let's look at what we covered today. We looked at the basic introduction to implied covenants. We said the meaning of implied means it was not in writing. The definition of covenants was an obligation, and that the foundation for all of these covenants is the reasonable, prudent operator standard. Not the reasonably prudent operator standard, but the reasonable, prudent operator standard. What would an operator similarly situated with the same facts, the same circumstances, what would a reasonable person do under the totality of the circumstances? And so we say, well, a reasonable, prudent operator would protect the lessor's lease from drainage. They would market that production. That lease is irrelevant if they drill on it, but they don't market the production. We've got to make sure that the lessor is going to get paid. Again, that's the public policy interest. We want people to be able to support themselves. So it does us no good if the oil and gas company just drills a well to determine if there's oil and gas under there, but does not market the production. And they've got to market it within a reasonable time and within a reasonable price. And they cannot engage in self-dealing where they sell it to a shell company for a lower price and basically use the or receive the profits from that. They have to reasonably develop the lease, and they have to further explore. They have to prove up that that formation. And that is basically the implied covenant in the oil and gas lease. Thank you for attending this webinar, and I look forward to seeing you in the next one.